The third time in 3 years, the issue of abortion is back before South Carolina's highest court. This morning, the state Supreme Court heard arguments in a challenge brought by Planned Parenthood against South Carolina's fetal heartbeat law. Your South Carolina State House reporter Mary Green was in court for that hearing. She joins us now with the details.
The last two abortion cases before South Carolina's Supreme Court challenged whether the state's abortion law was constitutional. The question before justices on Wednesday was different. At what point exactly in a pregnancy do abortions become outlawed?
We are here today seeking binding clarity about when in pregnancy a fetal heartbeat, as defined by the Fetal Heartbeat Act, occurs.
The law bans abortions if the unborn child's fetal heartbeat has been detected, defining fetal heartbeat as cardiac activity or the steady and repetitive rhythmic contraction of the fetal heart within the gestational sac. Nowhere in the law does that specify an exact time in a pregnancy in terms of weeks or days. But Planned Parenthood argues it should be enforced around 9 weeks, which it says is approximately the time an embryo develops into a fetus, without which there can't be a fetal heartbeat.
It's not for a court to rewrite a statute.
But the state argues enforcement should begin around 6 weeks into a pregnancy, which is what's in effect around South Carolina right now. Attorneys for the state noted that 6-week timeline is how Planned Parenthood itself and opponents of this legislation described the restriction when they were fighting its passage at the State House and in the courts.
You have Planned Parenthood calling it a capital S, capital W, capital B, 6-week ban more than 300 times in their filings. And in Planned Parenthood 2, in their brief in that case at page 42, note 50, they called the 6-week mark the hallmark feature of the 2023 Act.
And they argued it was clear the General Assembly intended for this ban to go into effect around 6 weeks into a pregnancy.
You've got days of debate in the Senate and the House, and never a person says this is a 9-week or this is a 10-week law.
And there's no timeline for justices to rule in this case. Reporting Columbia, I'm Mary Green.
Planned Parenthood argued clarification is needed in this case because without it, abortion providers will follow the strictest interpretation of the law because of the severe penalties they could face for breaking it. They say that would further restrict abortion access across South Carolina, where it is already extremely limited.